Hey there, welcome to another College Investor audio show, and thanks for joining us today as we take a look at how the Education Department is actually accused of blocking student loan forgiveness. Is that true? Is it not true? Is it kind of true? Let's take a look. But before we do, just want to remind you that anything we talk about on the podcast, you can always dive really deep into at thecollegeinvestor.com. All right, let's take a look at this. So the American Federation of Teachers, which represents 1.8 million members, has intensified its legal challenge against the Department of Education and Education Secretary Linda McMahon. In an amended complaint filed this week, which you can see the PDF file, by the way, we have links to all this stuff at thecollegeinvestor.com inside this article, the union seeks class action status on behalf of millions of borrowers it argues are unlawfully being denied access to IDR programs, income-driven repayment, and public service loan forgiveness, or PSLF. The filing follows a timeline in which the department froze processing of IDR applications for months, leaving a backlog that started at 2 million borrowers, but still is blocking more than 1 million borrowers. So the AFT argues that even as processing resumed, the department has effectively blocked forgiveness by halting loan forgiveness under IDR plans and allowing a separate PSLF buyback backlog to climb above 74,000 applications. The complaint alleges these delays and denials violate federal statutes that require the government to offer affordable repayment options and cancel loans after 20 or 25 years of repayment or after 10 years of public service. The union is pressing the court to enforce these obligations before the end of the year, when the student loan tax bomb resumes. So here's how borrowers are harmed by all this. The amended complaint, following up from the lawsuit filed earlier this year, highlights borrowers who have already surpassed the required payment counts for forgiveness but remain trapped in repayment anyway. Here's a quick example. Borrowers on IBR had to make 240 or 300 payments before qualifying for forgiveness. However, the DOE has paused processing this forgiveness for system updates, air quotes, can you hear them? Borrowers are required to continue making payments until the student loan forgiveness is actually processed. Refunds will be given, but that can take months. So for some, the delays have meant choosing between loan payments and essential expenses like, medical care, your electric bill. Others fear that if forgiveness is not processed by the end of 2025, they're going to face steep tax bills when discharged balances once again count as taxable income. The union contends that the department's actions actually force borrowers to forego necessities, contemplate even bankruptcy, or delay major life decisions. But beyond financial harm, the filings describe emotional stress, sleepless nights, anxiety, just a general sense that the government has broken a promise. Wouldn't be the first time. Anywho, the legal arguments. The AFT's case rests on two main claims under the Administrative Procedure Act. Number one, unlawful withholding of benefits. The union argues that Congress mandated the department to offer and process IDR plans, as well as to cancel loans when statutory conditions are met. So by suspending or slowing these processes, the department is unlawfully withholding benefits. 2. Arbitrary and capricious action. The department's refusal to cancel loans, even under plans unaffected by litigation, runs contrary to its own statutes, regulations, and contracts with borrowers. So the AFT argues, this has no rational basis and violates administrative law. The complaint emphasizes that nothing in the Eighth Circuit's injunction against the SAVE plan prevents forgiveness under older IDR programs like IBR, ICR, or PAY. Yet, the department has stopped discharges under those plans as well. The lawsuit also points to congressional action. We are not taking sides here, we're just stating the facts, okay? The One Big Beautiful Bill Act, or the OBBA, signed in July, removed the requirement that borrowers show a partial financial hardship to qualify for IBR, expanding eligibility. The department, however, continues to deny IBR applications based on that outdated requirement. The Department of Education says the partial financial hardship requirement will be removed by winter 2025, but borrowers attempting to switch plans now will be forced into ICR, asked to consolidate their loans when they may not even need to, and receive inaccurate information on the student loan repayment estimator. ARG! Why January matters. Okay. One of the big pushes in the case is the looming tax change on January 1st. Happy New Year. So, under current law, student loan forgiveness through IDR plans is not counted as taxable income. That provision expires at the end of the year due to changes from the OBA, One Big Beautiful Bill Act. Unless the department processes loan forgiveness before then, borrowers who finally get relief in 2026 could face tax bills on balances. Borrowers can use our tax bomb calculator. Love the name of that. The tax bomb calculator to assess the impact of this. You can find the link inside this article, thecollegeinvestor.com. Okay. The ATF argues, or AFT rather, argues that this deadline magnifies the harm of delayed forgiveness and justifies the need for immediate injunctive relief. PSLF discharges will remain tax-free, but IDR borrowers risk being saddled with an unexpected tax burden unless their loans are canceled before the deadline. So here's what happens next. The union's motion for a preliminary injunction asks the court to order the department to 4 things. Number 1, resume loan forgiveness under IBR pay and ICR plans for borrowers who have reached the required 20 or 25 years of repayment. 2, cancel loans for PSLF borrowers who have met the 120 payment requirement or have pending buyback applications that would make them eligible. 3, halt the practice of denying IBR applications based on hardship rules that no longer exist. And 4, process the mounting backlog of IDR and PSLF buyback applications at a meaningful pace. If granted, the injunction would apply to all affected class members, not just the individual plaintiffs. The department has not yet formally responded to the amended complaint or the motion for injunction. Officials have previously defended their actions as necessary given the ongoing litigation surrounding the SAVE plan and have pointed to progress in reducing application backlogs. The court is expected to hear this complaint in October, with hearings likely to follow later in the fall. We will continue to follow this, for sure. A decision on the injunction could come before the end of the year. That's good, though it kind of remains unclear whether the court's going to grant broad relief in time to protect borrowers from all the tax bomb that's coming. But for now, millions of borrowers remain in limbo, waiting to see whether the courts will force the government to deliver on promises of income-driven repayment and eventual loan forgiveness. And that is our show for today. If you want to dive deeper on this topic and anything else we ever talk about on the podcast, check us out at thecollegeinvestor.com or follow us, like us, whatever, all over social media. We're pretty much anywhere you are. Just search for The College Investor and you'll find us. Thanks again for stopping by today, and we'll talk to you again real soon.